Everybody. Oh, now we've really started. Okay, welcome everybody. Thank you for coming to our Justice for Families panel about domestic violence. And I think this is the fourth Zoom that we've done. I am Judy Hafner. I'm an attorney here in Henderson County, and I have worked in the past with exclusively with victims of domestic violence. So I'm going to be the moderator today. If you have any questions as we're getting started, there's a Q&A box at the bottom of your Zoom. So if you have any questions as we go through, if you want to put them in there, if you have technical questions, somebody will answer those. But if you have questions about any of the topics that we're discussing or something we've neglected to bring up, if you put that in there at the end of the hour, probably about the last 15 minutes, if everything goes well, we'll answer any questions that are in that box. So you'll also receive a survey link at the end that is needed for your certificate of attendance for a free CLE. So when you get that, if you'll go ahead and answer that. And we do have one more panelist that's going to be joining us. So we're kind of waiting for that. As we wait for that, I wanted to just announce that we're discussing today enhancing access to justice for survivors. And some people think of that as victims, those of us that have been in the fight to prevent further acts of domestic violence or sexual assault prevention. We use that survivors term instead, just for those of you that are wondering why we're saying that word. Okay, so I briefly introduced myself. My name is Judy Hafner, and I am an attorney here in Henderson County. And I'd like to thank the panelists who are joining us here today. We do have a district court judge, Emily Cowan, who's going to be joining us in a minute. She's literally in court at this moment. So she's going to be a few minutes late. Also joining us from District 29B Public Defender's Office is Dennis Maxwell. And I'm going to ask everybody to share some information about themselves in just a little bit. And we also have from Safe Lights Family Justice Center, the manager, Daniella Wasseldornik. I hope I said your name correct, Daniella. And then also from Safe Inc. in Transylvania County, with the Family Resource Center director out there is Lee Evans. And so welcome to all of the panelists, and thank you so much for joining us. I have just an update that the judge is in fact on her way. So, okay, so I'm going to start with you, Dennis. I know I said I was going to start in a different order, but welcome to the panel. I'm going to start with you. And if you'll just kind of share a little bit about your career journey as an attorney and how in your career you've sort of witnessed or come across survivors of domestic violence.
Sure. So I've been with the Public Defender's Office for 8 years now. And before that, I was in private practice here in Henderson County, where I took all kinds of cases, including DSS and other cases, and civil matters as well, and domestic cases as well, 50Bs, and ran the whole gamut. Since I've been, and when I was there, obviously I worked with victims who wanted to get who sought 50Bs, and obviously defendants who were either fighting 50Bs or charged with domestic violence crimes. And obviously in the Public Defender's Office, I deal with domestic violence offenses all the time. I'm usually on the defense side, though often I have contact with folks who are defendants who are actually survivors, who either are charged falsely, or they're often charged as it became a struggle. They were defending themselves from other domestic violence from another perpetrator. So I've seen it kind of from all sides, and having to deal with both sides, and that's sort of my experience. It's a complicated issue, and it's never easy. So that's my take so far.
Okay, awesome. Thank you so much. Oh, sorry, I was muted. Daniella, I would ask for you to do the same thing. If you'll just kind of share your career journey, how you came to do this work, and maybe explain a little bit about what your position is at Safe Light.
Absolutely. Thanks, Judy. My name is Daniella Wasseldornik. I am the Family Justice Center manager out here at Safe Light in Henderson County. So we are the umbrella organization under which we're prepared to serve survivors of intimate partner violence, sexual violence, as well as our kiddos, our minors who might have experienced abuse or neglect in their childhood there. I came to this work, or actually, I guess I came to Henderson County by kind of indirect means, cut my teeth as a volunteer sexual assault survivors advocate with Sexual Trauma Services of the Midlands in Columbia, South Carolina, which led me to my first job in the field as a domestic violence advocate in the state of Florida. From that time, I worked really closely with survivors as well as their children in the child welfare system. And eventually that took me out to the Pacific Northwest, where I earned my law degree from the University of Oregon. So I am not a practicing attorney right now. This is another way that you can use that law degree. But I've come here to Henderson County to help kind of move along in our next steps with our Family Justice Center, and really looking forward to growing from the legal advocacy that we're currently providing under my program, and seeing how we can really put that on its feet and do some more additional meaningful work for survivors in Henderson County and our surrounding communities.
Okay, awesome, great. Wow, you've been all over the place. And then Lee, if you will do the same thing, if you will kind of give all the attendees and your co-panelists sort of an idea of your career path and what brought you to work with survivors. Lee, if you'll unmute.
Yeah, sorry. Yep, I just did. Yep, thank you. Sure. So I'm the director of the Family Resource Center here in Transylvania County. We are a collaborative partnership, similarly to what they have in Hendersonville, of a one-stop shop for our survivors of domestic violence and sexual assault. We also work with children, and the idea is to bring everybody to the survivor and not have the survivor, bounce around town in our rural area to all the different agencies that might be able to provide some support. So as an extension of SAFE, we've got all the services that SAFE offers, such as therapy and help for the kids and assessments and trauma assessments. We go out to schools, to work with folks there to try and change the paradigm a bit of what sexual assault and domestic violence looks like. I came to this, I've supported domestic violence issues, supported the fight against domestic violence issues for probably about 2 decades now. I used to live in Houston, Texas, and I was on the board of the Women's Home in Houston. When I moved to this area, I was asked to also help out with SAFE, and so that got me into that here locally. I've seen domestic violence cases around the world. My career before I came here was in hardship postings around the globe, and we advocated against domestic violence in different cultures and in different kinds of surroundings. And that was particularly tricky because in some cultures, domestic violence is absolutely accepted. And so that has given me quite a bit of insight as far as reaching some of our marginalized communities here in Transylvania County.
Okay, well, that's fascinating. If we have time at the end and no questions, I want you to talk about your experience in other places. That's great. And last but not least, the Honorable Emily Cowan is joining us. Thank you for coming, Judge. We did some introductory remarks before you were able to join us. My understanding is that you came straight from the bench to join our panel, so thank you for being here. We are just starting with some introductory, just if you could kind of give the attendees and the co-panelists an idea of your career path as an attorney, and how you first became aware of domestic violence. Obviously, as a judge, you're not really an advocate for any particular organization, but if you would just kind of give a brief overview, and then we're going to move on to specific questions in a little bit.
Okay. Thanks for having me. Sorry that I was late. They never break on time for lunch. And in theory, I'm in charge of that, but in practice, it doesn't tend to work out. So my name's Emily Cowan. I am a district court judge in Transylvania, Polk, and Henderson counties. This is my 9th year on the bench. Is that right? That's right. This is my 9th year on the bench.
Impossible, but that's right.
That's right, 9th year on the bench. And prior to that, I was, the beginning of my career, I was a prosecutor for 6 years. And then I was a guardian ad litem attorney advocate for 3 years. And I had a small private practice during that time. I was on the board of Safe Light when it was mainstay for about 6 or 7 years. I was on there for a long time. And so that's probably when I had, as a prosecutor and as a board member at Safe Light, probably when I had the most experience with domestic violence, victims, survivors, offenders, everyone in the world of domestic violence. And then as a judge, obviously, I hear a lot of domestic violence cases criminally, and then I also handle a lot of restraining orders, what we call them 50Bs in North Carolina, but restraining orders for domestic violence is a big part of my job as a judge. So that's my brief version of my involvement with domestic violence in my career history.
Okay, awesome. Thank you. I think I'm going to switch it around and let you go first. So our first question is really about, because this is about enhancing access to justice for survivors, if you would describe the services and prevention efforts that you see in the courtroom that help survivors that participate in the justice process, in how you define domestic violence personally. It's a really long question.
All right. Well, the first part with regards to the resources, I mean, the advocates that come to court with victims and survivors are a big help. I think that was probably in place when I was in the DA's office. I know it was, but it seemed to be, maybe one person was a liaison to court, and now we seem to have more people in those positions. They seem to have a lot of knowledge of the system. Hendersonville had a family justice center for a while where you could send people. I think there was some transition there, so I'm not sure what place it's in now. But so all of those services have been really, really helpful. I can't tell someone what to write on a complaint, nor should anyone. But just having some idea of what the pertinent information is useful. And I feel like the advocates really help with that. They help them navigate it's not a scary process for us because we're in court every day. I mean, Judy and I are in court all the time. I'm trying to see who else is on this call. Dennis is in court all the time. So court doesn't seem frightening to us, but it's really frightening to people that are not familiar with it. And so having those advocates is huge. Having those overarching agencies that are, getting complaints filled out ahead of time, helping people, take the steps from the courthouse to the magistrate's office to the civil process, all those things, that's just really helpful. So I've certainly appreciated those interventions that I have seen in the past 9 years on the bench. And then with regards to my definition of domestic violence, I mean, I guess it falls right along the statute, huh?
That's a hard question.
I mean, I think, North Carolina defines certain things as domestic relationships. And so that's what I'm bound to do. I don't know that I've ever taken the time to explore my personal definition because I'm busy trying to figure out whether or not a case fits in the definition from the state. And that's actually really odd because the definition to get a restraining order, as far as what is domestic violence and what is not, is different from the definition for a bond set. They define those two things differently. So sometimes I don't set a bond, it's set by a magistrate because it's not a domestic case, but I might very well be able to issue a restraining order in that same case. So it gets to be a little bit tricky sometimes, but So I don't know that I've taken the time to develop a personal view. I just deal with the statutory one.
Okay, thank you. And that's great information that probably very few people have had experience on both the civil and the criminal side to know that even the definitions within the law and the statutes are not in agreement, which is why we need all of the court advocates that we do have. And Lee, if you would speak to the same thing, you gave us sort of an idea of what your organization does, but if you would maybe talk about what the preventative services are that your organization offers, and then how you define domestic violence.
Sure. SAFE has a number of programs that helps with prevention. So as I mentioned earlier, we've got some advocates that go out to the schools in some of our rural areas. Well, we're all rural, but some of our more insular areas. And that's been helping to shift the paradigm a little bit. You know, we find that it takes a generation sometimes to really move the bar, and yet working with the children to change their idea of what domestic violence is or whether it's okay or not. And a lot of the kids that we're working with are legacy children for domestic violence. Their families have been through it forever. They see it as a normal thing. They're socialized to believe that that's just what life is all about. So we have a really great program of outreach into the schools that is trying to help to change that idea and that opinion. SAFE also works from an empowerment model to where we absolutely have our survivors and victims. You know, they get to make the choices of where they want this to go and what they want to do. That we've found has been incredibly successful in backsliding and going back to their abusers in many cases. In some cases, you know, if they're just not ready to do that, and again, if it's not from their perspective, it's not sustainable. You know, we may be able to get someone to stand up in court today and say, yes, I want this to go through. And then, you know, within 3 days, they're back to their abuser. So the empowerment model that SAFE employs has proven to be very effective in helping with that. We also have a program called Domestic Violence Intervention Program, or DVIP, and that has helped reduce recidivism of our abusers. If they fulfill their 26-week obligation for that program, we find that they're less likely to return to abuse others. So from a prevention standpoint, that's some of the things, just a tip of the iceberg of some of the things that we do to help prevent domestic violence and support our survivors. From a definition, I am along the lines of Judge Cowan to a certain extent, where we define it at the Family Resource Center. I look at what the statute says for protective orders and what domestic violence is. That's not always as clear cut as people would like it to be. I mean, the statute it's all in black and white, and that's easy to read, but a lot of people believe that domestic violence looks differently. So we've got the literal definition by the statute for us. We've got the definition you might find in the dictionary. And then, overall, we see domestic violence as a philosophically about control. And so that also, creates a little bit of gray area for some of our victims and survivors.
Okay, awesome, excellent.
Judy, you're on mute.
Okay. Dennis, you're up next. I think you read lips because I felt like he knew I said that. I don't know that your organization participates in prevention efforts and services, but if you feel like there is a coordinated effort from your organization itself, if you would kind of explain that to us, and then if you have a definition of domestic violence that you would share with us also.
Well, let me start first with saying that our job in the Public Defender's Office is a little bit different than everybody else. We don't necessarily advocate for survivors. Though sometimes we end up doing that if we have someone who's been charged, like I said. So let's separate that out and say that when we have somebody who is a survivor as a client, who is charged at the same time as their abuser or was charged falsely, which happens far too regularly. The biggest thing is we try and get them services. We'll refer them to Safe Light here in Henderson County or Safe in other counties, and try and get them help. And obviously we're going to advocate for them in the context of their criminal case as much as we can. we'll urge them to see about getting protective orders, a 50B, send them to the magistrate. We can't do that ourselves, obviously, because all we can do is represent them in the criminal case. We'll refer them out to Pisgah Legal Services and other attorneys if they need assistance in that. But overarching, the thing about domestic violence cases and domestic violence is, especially in the criminal context, is that it's always very complicated. There are lots of forces within family systems that cause this to happen. It is 100% about control, and it is 100% about abuse. But there are lots of competing concerns from everybody, especially if it's in the context of not just a couple, but a family. And there's financial concerns. There's all kinds of other concerns that make dealing with them from our perspective, very complicated. My job, I see it as trying to reach, an outcome that is just. Obviously, we want to get the best outcome for our client, whether it's a survivor who's our client or the abuser himself. But ultimately, we want to have we want a just outcome, and that looks different in almost every case. Sometimes it means a person needs to go to jail, and I definitely accept that. Sometimes it means that there are a myriad of different options that we can construct to try and deal with it, where it's going to either make a separation more realistic, or in some way trying to knit the system together in some way if there's children involved. Again, there's all kinds of civil law implications in cases like this, and oftentimes it's caught up in a civil case. The help that we get from Safe Light and other organizations like that in order to provide support for everybody, including the domestic violence intervention program, if that's indicated, can be a huge help. And often, and the efficacy of that is actually quite good. That you have people who have first-time offense, they were drunk or whatever it happened to be. They usually take part in the 26-week program, and often everything is, I don't see them again, which is my view of success. If I don't see a client again, I'm happy. Our job's a little more complicated because we've got to deal with all the different sides, but that it's, domestic violence is an issue that makes for complicated criminal cases and making for complicated outcomes. As far as the definition, I'm going to defer to the statute because that's really that's the sea that I swim in. And I have no way else to define it. I get cases that they come to me and how they're dealt with. But anyway, it's like I said, complicated, and the help that we get from other organizations, and we make referrals to them all the time. That kind of keeps things so.
Awesome, thank you. Well said. All right, I kind of want to scratch the definition of domestic violence, but I have a feeling, Daniella, you're going to be the person that has one. So same question. What kind of services do you offer that focus on prevention of domestic violence that impacts the justice system, or when survivors interact within the court system? And if you do have a definition of domestic violence, if you'll share that with us.
Absolutely. And if it's all right with the rest of my panelists in our audience, I'd actually like to flip the order there and talk a little bit about defining domestic violence first. For us, over at Safe Light, we have a really broad, really general sense of what constitutes domestic violence. We're looking at abuse that is perpetrated by one partner, current or former partner, against another partner. And so that can look like financial abuse, that can look like emotional abuse, that can look like isolation from other family members or close friends. That can look like electronic abuse. If you are a person who has a Facebook account and your abuser is also logged into your Facebook account from their phone, they can track what you're doing on that particular social media site. And so for us, we're looking at this broad gamut of behaviors, but really a pattern of behaviors that exerts the kind of control that we've heard mentioned through the definitions from our previous panelists' response, or rather our panelists' previous response. I will say that certainly from our legal advocacy side, we do defer to North Carolina's legal definition, the statutory definition of what's considered assault on a female or domestic violence. But there is one portion where Safe Flight extends our services a little farther than what the statute might recognize as a person who is surviving domestic violence. And that is that the language in a lot of our court documents and our laws here in North Carolina states that we're talking about folks who are members of opposite sexes in romantic relationships previously or currently. Here at Safe Flight, we're providing those services regardless of gender identity or sexual orientation. And we understand that sometimes someone's situation based on their sexual orientation, gender identity, and expression may not necessarily meet certain terminologies that our courts and our laws are prepared to provide relief under. And so we can do that on a less formal level. The good news is that there are so many categories under North Carolina's domestic violence laws that if you don't fall under that opposite sex category, you likely fall under another. And so we are able to capture a lot of folks who may be experiencing interpersonal or intimate partner or domestic violence with that statute, but just acknowledging that that opposite sex terminology sometimes can be a barrier for folks achieving the kind of support and justice that they need. When it comes to prevention efforts at Safe Flight, we are really starting to build up and build certainly a certain robustness to that kind of programming with our new outreach programming, which is going to include education in our schools, education and professional development for our area professionals. That's super exciting. But the good news is that we have a whole battery of other services that provide what is known as secondary and tertiary prevention, that we are mitigating the effects of immediate abuse with our shelter programming, counseling programming, our job training programming, and we are the keepers of the domestic violence intervention programming here in Henderson County. We're also looking forward into how do we cope as a community with what's going on and kind of mitigate the effects globally. Again, that job training program and what we're doing at the Family Justice Center are the ways that we address that.
Awesome. Okay. I think probably while you're still in the unmuted hot seat, that's what I'm going to call it now on Zoom, I'm going to let you give an example of the next question we have, which is, what examples have you seen personally that you felt harmed or helped survivors? And this would be like more a case-by-case basis, if you have any of those to share with us.
Yeah, and I'll spotlight one specific example, because obviously I could go on all day on this topic. And on the positive side, that one thing that we've really seen in the services we provide here at the FJC is that this non-judgment and meeting survivors where they're at is not just critical to building the trust that's necessary to support someone through healing and recovery after these types of experiences, but is absolutely mandatory if we want to make sure that we are supporting folks through the course of that relationship. We know that relationships, romantic relationships exist in most of the cases that we see walk through our doors, which means even though from the outside we may be looking in and saying, oh my gosh, he hits you, he shoves you, you should want to leave right now, get out of there, we're still looking at a breakup happening. And so if we can think back to the last time that we broke up from a serious relationship, heaven forbid it was a relationship where we had kids with someone, that is never easy. And then when you add this dynamic of violence, it gets even further complicated. For us, we recently had a client who came to us for services and instead of pursuing legal action, left the area. We thought, all right, that's great. That's a safety plan. We made sure that you were away from this person that was causing you harm. She returned to the area though. It was hard for her to make it in her situation where she was at. And she came back and then she called us back, which for those of you who have provided services to survivors know that is, oh my gosh, my heart just went pitter pat. The choirs of angels started singing. The ability that that we had to develop that trusting relationship so quickly with that person that even when they changed their mind and they thought they might be a burden to us, they came back and said, hey, I still need your help. That for me was evidence that when we are building that trusting relationship, that non-judgment, that validating language, we can move the world for survivors. And that, for me, that guides all of our interactions.
Awesome. Great. I appreciate that. That is, yeah, to have someone call you back. That's huge. So Judge Cowan, if you would talk about that also, and from whatever perspective comes to your mind, what examples you've seen that have harmed or helped survivors. Because I know that you've had experience with them, as you said, from an attorney standpoint with child welfare and guardian ad litem program, and obviously a lot of experience seeing what might have helped or harmed from the bench. So any example you have from any of your background?
That's a hard question. I know that is helpful when the judge is patient and compassionate. I do not always embody those two attributes. I really liked early in my career and until recently, really, to have the people that were asking for restraining orders ex parte come to the bench. So they didn't have to talk in front of everyone. COVID has sort of shut that down. And so more often people are having to sort of air that information out loud, in which case I'm trying more and more to go from the written complaint and only ask clarifying questions so as to not make them have to stand up in front of a room of strangers and talk about, intimate details of their life. To that end, for those of you who are advocates and help with the paperwork, if they go ahead and fill out if there's been a sexual assault on the paperwork, then I don't have to ask any additional questions about that. And I feel like that's probably one of the most intrusive questions one would have to ask. And a lot of times now that I am doing it out loud, I skip it because I don't feel like people want to have to answer that in front of a room full of people if they didn't indicate it on the paperwork. I don't delve into that any more deeply, which is interesting because when I did have them at the bench and I would ask that, a lot of people who didn't put it on their paperwork would indicate that that was a problem. So I don't like missing that question. I just haven't figured out yet how to balance their privacy interest with getting the most accurate information on the paperwork. So I know that having a judge that is compassionate and patient and helpful is useful. Like I said, I'm not always that person. I try to be, but we see these cases in the midst of everything else. So it's like, hundreds and hundreds of cases. And by the way, do these delicate restraining orders at the same time. So I don't know that we're always in the best space to do them at the early stages. Now, when the hearing comes up, usually we're at a better stage to do that. I think it's helpful when there's good communication with the DA's office so that like I spent a long time explaining something to someone the other day that wasn't really my role because the case had gotten continued criminally. So then the restraining order was going to track the criminal case. The person wanted the case heard. The case was a felony. So I can't make them hear it in district court. I don't have any jurisdiction. So I had to go through all that with the victim in court. She was upset. Her mother was upset. Everyone was crying. Not me, but everyone involved was crying. And it was just a really negative experience in the court system for her. I actually didn't have an advocate that day, oddly enough, that I can remember, because I would have utilized them if I had. So I think that, obviously the more patient and compassionate we can be towards everyone in court is helpful. Like I said, once again, that doesn't always mean that I hit that mark. It's like, you want to be the mom that reads to your kid every night. We don't always hit that mark. But so I think that's important. I think, as far as things that have been harmful, I think it's always harmful when we re-victimize, people in the court system, which often we do. Whether or not it's, it's not always attitude related. A lot of times it's just the process. The process, defendants have constitutional rights. They have the right to confront their accuser, So would it be great if we could do these things in a more informed, trauma-informed way? Sure. It's just that due process isn't necessarily set up that way. And so I don't know that I have the most ideas about how to make that better, although I think the advocates are key to that. I will say that. Having a person with them that can say, this is not personal. This is how the system works. This is not, this is not related to you. This is just how this goes, and help them through it. That's really great. I think if they have communication with the prosecutor that's going to prosecute their case, if they feel like that person understands what they're going through, if they feel like they're able to contact that person. Sometimes I feel like one of the most important things I did as a prosecutor when I did that role was to say, you've been personally served with a subpoena. You have to come to court. It's not your choice. I'm prosecuting this case, not you. So you don't have to take any ownership of the fact that this case is going on, because I'm going to prosecute it with or without you. And if you don't show up, I'm going to enforce a subpoena and force you to show up. Does that sound like the most pleasant way to do things? No. But at least it took the burden off them feeling like they were driving the bus as far as, he doesn't want me to prosecute him. I'm doing this. I just said, no, it's not you. It's me. I'm doing this. And that was true. I did. If you didn't show up for my subpoena, I moved for vindictive prosecution. I show cause people. I did try to handle that so that I was the bad guy, not the victim feeling like they had to be in that role. I'm sure some victims like that. I'm sure some victims really hated that. But that's how I handled that pretty consistently when I did that role. The last thing I'll say is one of the rare things, not rare, it actually happened fairly often, that I was surprised by. One of the surprising things when I was a prosecutor was how many offenders told me how much they had benefited from the classes. To echo what Mr. Maxwell said, he wants to not see that defendant again. And a lot of times when they go through the 26-week program, you don't. If they're successful in that program, I don't know what y'all's numbers say, but we notice a lower recidivism rate with people that do that program. I had a guy stop me in the hot dog world. I was really young, and he said, you sent me to Mainstay. And I was like, oh God, now I'm going to die in hot dog world, and that's going to be the end of my story. And he said, you really saved my life. That class saved my life. That teacher was great. That experience turned me around. And that was really gratifying for me, because I thought I was going to die in hot dog world and I didn't. But also because, fantastic, so his family's functioning better. And I had nothing to do with that. I didn't teach the class. But just the fact that we have that program, that it holds people accountable, people can go to that program and get the help they need, was really great to hear. And that was 14, 15 years ago. So I think the programs and the opportunities have only improved since then, thanks to the work of most of the people on this call. So we in the court system are appreciative of that. And we welcome your input as far as how we can do our jobs better. I welcome your input. I don't really know if anybody else does or not, but I appreciate it when I get some feedback from y'all about how I can better serve in the role that I'm in. So please feel free to let me know, and I'll take some notes.
Okay, well, that was really good for what you thought was a hard question. I loved all your answers. In fact, all of them gave me ideas of other questions and things that would be helpful to have insight from somebody's perspective that understands domestic violence in the way that you do, who's been in multiple roles, and particularly a view from the bench, which is a different view. And probably you see the nervousness or the effect on them in a different way than the rest of us do. I don't know.
And a lot of times I don't see it until it's too late. A lot of times I don't see it until I've asked like 3 sort of blunt questions and they start to tear up and I'm like, oh, crud.
Yes.
This isn't their 10th 50B of the day. This is their first 50B of the day. And I have to sort of reel it back in and then say, I'm sorry you're here under difficult circumstances. Let me try to ask you these questions as quickly and painlessly as possible so we can get you out of here. And they're usually grateful, but it is hard to remind yourself that something you do over and over and over again every day is new to them. Or it's the first time they've had it's first time they've been able to follow through, right? And so the last thing you want to do is discourage that. And so I do have to reel myself in sometimes. I'm not the quickest at recognizing that someone's having a hard time. It usually takes me a minute. So that's another reason why I'm happy for the advocates. So that someone who is warm and fuzzy is there with them, because warm and fuzzy is not my forte.
Someone can take the time that you don't have. That was such a good answer that I think that you may have bought yourself another panelist participation thing, but that's just a foreshadowing, more to come. So actually I'm going to go ahead and ask you, Dennis, because what this same thing, the examples you've seen that have harmed or helped survivors, since this is based on their access to justice, one of the things that Judge Cowan is talking about is that there's a room full of people. And I remember when I was first working in representing victims of domestic violence, primarily with 50Bs, for a while, there were judges in Buncombe County, because their dockets start so much later, like maybe 9:30, they would take the people that were applying for ex partes into like the judge's chambers, so it was private. And I'm just wondering, like, if through your work in representing both sides of this issue, or seeing people that are maybe falsely accused and people that are rightfully accused, what you think may be helpful for the survivors, like in real time, like the judge was speaking to. This is happening, which is the problem with everything with domestic violence. This is happening in the middle of everything else.
Yeah, that's a good question, because it's especially with 50Bs, protective orders, it's the ex parte doesn't necessarily have to be done in open court. And I actually have a lot of sympathy for Judge Cowan having to deal with that on the bench in the middle of criminal court. And it gets hectic. It slows everything down. Everybody gets pissed off because, hey, we're in the middle of criminal court. Why are we stopping everything to do this? But, we have to recognize that it's important for the person who's there, the person who's seeking that order. One of the problems with 50Bs is that they're civil, so nobody's entitled to a lawyer, right? You can hire a lawyer, but nobody's entitled to a lawyer, not the defendant, not the plaintiff, and that can really hamper how the process flows. And even in cases where I'm representing an offender and there's a 50B against him, I can represent him in the criminal case, but I can't represent him in the 50B. And it gets very complicated procedurally how that gets separated out. Oftentimes I just jump in and be like, especially if it's an easy consent, we just consent to it and we're done. And I'll kind of walk them through that. But oftentimes if there's a hearing on both, then it becomes really, really complicated. I don't know what the answer to that is. They have to be tried together oftentimes because the facts are the same, right? It doesn't make any sense to even though there's a lower standard of burden of proof on a 50B, it's still the same facts and it's prejudicial to the criminal case, right? So, there's no easy answer to that. If a judge were to take a survivor who's seeking a 50B into chambers and for an ex parte, I think that would work. Judge Cowan, I don't think it's every day that 50Bs have to be in criminal court, right? I mean, ex parte 50Bs can be heard in any court.
Well, yeah, technically it's every day in Henderson. The way it works is every day but Friday, because on Fridays you have ACH, and so your new 50Bs go into ACH, which is definitely a better place to hear them. You know, and the chambers thing is hard too, because then the room seems to think like, what's going on in there?
Right.
You know, and I mean, and so then it's like, well, she talked to the judge in chambers. Is that judge now recused from the case? Like, it gets a little bit dicey. And like I said, my solution during COVID, since I don't want to be near anybody, has been to maybe give the complaint back to the advocate and say, can you flesh this out a little bit more? Can you put a little bit more information in it? Right. And there's also some Court of Appeals cases about not having things in the complaint that are later granted.
Right.
Like your failure to pray for something. Right. Can cause problems there. So it is useful to have a fairly thorough complaint. Do I like the ones with 12 attached pages? Not so much. But if you can at least hit all the pertinent information, then that's helpful. But yeah, other than Fridays, they are in district criminal. And then in the other counties, they're literally in whatever court you're in.
Right.
So there's only one court going on at a time. So whatever court exists is where you're doing your 50Bs.
I mean, one of the things that, from just as a sort of general scheduling matter, that with respect to criminal district court in Henderson County, is, and that our office, I know, would like to have, is like a time block for certain things, like, you know, like first appearances and for hearing ex parte 50Bs or other civil motions. It would be good to say at this point in the morning or at this point in the afternoon or whatever, that's when it happens. So everybody is aware of what's going on. I think sometimes it just is kind of hit or miss. And I'm not sure that that's even possible with respect to ex parte 50Bs. I don't know if they all come up at once or the clerks bring them up piecemeal.
They come up as they're created. And we did try that. We did try to not do domestic violence bond sets till after lunch. The problem was, to some degree, you felt like you were violating people's rights, right? Because judges on the bench, you're in custody, you have a right to have that bond set. But the other problem with it was everyone sort of had trouble. The officer, everybody sort of had trouble with it, and you never could seem to get things where they needed to be when they needed to be there. And so you were waiting around for this, but you couldn't do that because it was a period where you're supposed to be doing this. And so I like having, I shouldn't say I like it. I don't mind having 50Bs in criminal court because I can fill the dead space. Because a lot of times in criminal court, there's gaps between pleas. There's all this sort of unused space. And anyone who's met me knows that patience is not a virtue I possess. And so I want to move and I want to get things done. So I'm pretty adept at being able to pull up a 50B, get it done in the gap, and then move on to the next criminal plea. So I don't mind that so much. It's more just the number of people that are sort of watching them as they're trying to deal with this delicate situation. And I'm slowly but surely getting better at different ways to sort of manage that so they're not feeling quite so exposed.
Yeah.
Gotcha.
I think it's important. I think it's an important consideration for really any domestic violence case, is that it's such a personal matter, and it gets into the root of family dynamics and personal lives that other cases don't necessarily touch on. So I mean, and just to kind of touch on other examples that I've seen where survivors have been harmed. Obviously, the big thing is sort of retaliatory warrants and retaliatory 50Bs. Frankly, that happens a lot, and sometimes it's not a retaliatory for a criminal charge. It's retaliatory for something that's going on in a civil domestic case. There's a lot of that goes on, and that that's really very challenging to deal with. And I don't know how to put a stop to that. It's one of the things is in North Carolina, of course, for misdemeanors, a normal person can go down to the magistrate and swear out a warrant, and that is it has so many different ramifications, especially when it's retaliatory for some dude is pissed off because a woman got custody of his kids, for example, and he goes and takes out a warrant against the woman for whatever reason. And that's, that happens unfortunately with far too much regularity. So those are a lot of the issues that I see, and I'll leave it there.
Those are great issues. See, it's 12:49. We're already running out of time. We do have a couple of questions. Judge Cowan, I'm sure somebody wants you to come back to court, but you can't leave yet because there's a question specifically for you in the chat. But Lee, I would like for you to address, we're kind of having to have everyone have a different question at this point. If you could talk a little bit about what you think the potential barriers that survivors have in different personal and cultural backgrounds, how that might impact a survivor accessing justice in the court process, because it sounds like you've got a lot of different experience over the globe that might speak to that issue.
Sure, and thanks for the question. We're a rural area. We've got a lot of remote communities. We've got a lot of marginalized communities. It's hard to get to. We've got a lot of insular communities. I think some of the barriers are just basically remains the stigma of admitting domestic violence, sexual assault in some cultures and communities. A lot of communities that are insular, they kind of close ranks around this type of thing. It's hard to break in as an outsider. We either have to approach them by finding the way in, whether it's through a church, to get the communities to welcome us and allow us to come in and work with them, or even have people come into the Family Resource Center, and admit that something's going on. Sometimes it takes having someone from that community being the representative that they work with. They feel more comfortable with that. So it just depends. Stigma is still an issue. We try to destigmatize it, meeting them where they are at, whether that's physically or emotionally or philosophically. Sometimes we have a problem with some of our communities because of citizenship issues, and people don't come forward because they're very concerned, even though we tell them, this isn't going to be an issue. We promise. There's a lack of trust. There's a lack of trust in the system. There's a lack of trust that law enforcement will treat them the way they should be treated, or that the legal system will treat them the way that they deserve to be treated. We work long and hard to continue to convince our victims and survivors that we are here to advocate for them, and we'll do the best we can to make sure that some of those unintended consequences don't keep them from moving forward. Resources are an issue for us. Not necessarily just from the organizational standpoint, but there's no public transportation here to speak of. And so folks getting to either the Family Resource Center or the courthouse, that's a big deal. We potentially lose some of our survivors and victims because they can't get here. So we'll also make sure here at the FRC that we're telling them, listen, if whatever the barrier is, that's my job. My job is to remove all those barriers so they can go forward with this if they want to. I see that as one of my key, in addition to making people feel comfortable that they're supported in court, because it is scary. The process is scary. My job is to also say, whatever the barrier is, just let me know what it is. If you don't have time to eat breakfast, you don't have clothes to wear to court, you need someone for childcare, you can't get transportation, language is an issue, you can't spell, you can't write, we work with all of that. As Judge Cowan was saying, it's sometimes difficult to, if you've got 12 pages of comments, or you've got folks that ramble on or don't necessarily make a cohesive argument. We help with a lot of that as far as reading over victim statements, asking questions. People come in and they tell their story, and you say, okay, that's really good. Write that down. You give them a piece of paper to write their statement, and it comes back with, I don't like him, he hit me once. You think, wait a minute, we just talked for a half an hour on everything that you're complaining about, and yet that is very difficult sometimes to capture that on paper. So that in itself is also a barrier. It's one thing for them to talk to someone in a warm setting, and on a cozy sofa, or with some snacks and a cup of coffee in their hand. When you say, okay, now let's write all that down. And I apologize if it's making them look through it again. My comments always, the more you write down, the clearer it is, the fewer questions you might be asked in front of God and everybody. It's still difficult for people. It's difficult if they don't feel that they're literate enough to write. It's just difficult. So we spend an awful lot of time with people on that.
Okay. Yeah, I don't usually feel like we need more time on Lunch and Learns. We need a lot more time. Judge Cowan, unfortunately, every question in the chat is for you. I asked them to share the questions with you. Can you see them?
I see them. Okay, so Casey's question about virtual. I don't have a problem with virtual. I like it because, once again, people not near me, I can eat snacks. But I think the problem with that,
only you and I think probably can see the questions. If you'll.
Oh, sorry. I'm sorry. Casey's question is, I know some other counties conduct 50B ex parte hearings virtually. Could this work in our district? I'm happy to try and work on that. I think the issue is going to be with regards to like filing the paperwork, things like that. So that's to me the piece is, I think Casey is for for us, you, me, civil clerks. I don't know that the prosecutors will be involved, but to sort of figure out what the barriers are to that and work on that. But I know that several of our judges, at least, will do more things virtually. And so that's something I think we can certainly work on, because I have often, it bothers me that there's so many returns to court, especially early in the process. And God forbid you file it on a weekend. So then you have to see a magistrate, come back and see me or somebody else on Monday, then you're back in 10 days. And you're even back in 10 days, even if we know there's a criminal case that's on in 20 days. Because we have to bring it back in 10. So it becomes very burdensome for childcare and jobs. And so certainly that would be great. And so the answer to that, Casey, is let's talk later and we'll see what we can figure out. Next question for Judge Cowan is there anything that you feel court advocates could do to ease the 50B process for everyone? Are there any issues that regularly arise that can be mitigated by advocates working with those filing? One of the big ones is where you put the kids. If they're shared kids, they go on page 2. If they're not shared kids, they go on page 1. So if the people involved are both parents of those kids, page 2. People involved, not both parents of those kids, page 1. So that's a big difference. The other one that gets me a lot of times is, and this goes into the next question too, cases that are dismissed because it's mental abuse and sexual abuse is not considered. I mean, that's not true. Sexual abuse is on the form. It's in the statute. Sexual abuse, if it's articulated, should qualify for a restraining order. No two ways about it. Mental abuse is harder. You have to not cleverly, that's not the right word. You have to accurately articulate, any emotional, how's it go? What's the word I'm looking for, Judy?
Substantial infliction of emotional distress.
Yeah. So you have to show what that is. And the case law says that you need to be able to, like, I've been emotionally distressed, not useful. I have been emotionally distressed, and here's why. I've had to start taking anxiety medications. I've missed work because I can't sleep because I'm so upset. I regularly have panic attacks related to this. So when you're able to articulate and I ask that question all the time and people never answer it. So what is the emotional distress you have suffered? Well, he screams at me. Now, see, that's not emotional distress. That is the cause of the emotional distress. It is not the emotional distress. And I have the same problem when I ask what injuries people have suffered. They'll say, he hit me in the face. Okay, did that cause an injury? Not that I'm not upset that he hit me in the face. I am. But per the statute and per the forms I'm filling out, I have to articulate certain things. And so the reason that question is so important is because if he has inflicted injuries upon, or she has inflicted injuries upon him, then that qualifies for one of the factors that can result in them having a firearm removed from them. So that's important, right? And so I'm not asking that because I don't care that he pushed you. I do care that he pushed you, but the answer to that question allows me to do other things via that order. And similarly, the answer to what emotional distress or what manifestations of that emotional distress exist allows me to do more things with my order. So the questions we're asking seem sometimes callous, but they're related to what we can and can't do in a case. So, and the questions also relate to what we can and can't do with regards to custody and emergency custody. So a lot of times the things that are the most important for people getting these restraining orders, we need answers to those specific questions. So as an advocate, I would say read through that form really, really well and know what's in it, because the form tracks the statute. And then be able to answer the questions in those forms articulately, so that then those answers can be used to grant the relief needed.
Awesome. You guys, it is actually, I think our time is up. I don't know if y'all want to continue to answer questions. Judge Cowan, I know you're probably going back to court, but there are some more questions on here. So I guess I'm a little confused. I don't know if all the panelists can read the questions. I'm happy those of us that want to stay and talk about these, if y'all have a few more minutes. Those of you that do not, thank you for joining us. Thank you to our panelists. And thank you for Safe Flight and SAFE for participating and for setting this up. I think Judge Cowan just read that, thank goodness you didn't die at the hot dog roll. I see her laughing.
All right, I think we've got, I don't know, Judy, I think I read through all the questions I see left, and I think we got them all. But you know, oh, am I still muted? No, not muted. Oh yeah. I feel free to approach me at any time that you have questions for me in particular. I'm happy to answer them in court or off the bench. And if I can't answer it, like if it's too specific and related to a case, I'll just tell you I can't answer it.
Right.
So I'll, you know, I'm not saying approach me about specific cases, but anything general like this that you want to approach me about, I'm happy to answer anytime, and I'm flattered to be included in the panel. So thanks so much.
Thank you for doing it. It's important, and we have, all of you have so much knowledge. We could have done a much longer Zoom conference for sure. And I think that one of the things that would be really helpful probably is, it's not just, I think these questions are directed towards you, Judge Cowan, not just because you're the only judge on our panel, but as I read the actual language of some of these, it's that, why aren't some of the other judges granting relief that people might be entitled to? And I think that that's written because you do have such a depth of understanding of domestic violence and all of the control and power that is unusual, I think, but that's probably because of the different roles that you filled, and also probably from your board membership in the past too. So I would expect a call probably from Rebecca Alford that you're going to do the whole thing next time. You be the moderator. You can ask yourself questions and I'll just sit here.
No, if I'm in, you're in, sister.
Lee, I know that you're unmuted, and you are too, Dennis. Did y'all have anything that y'all wanted to add to any of these questions?
No, I did not. I'm good. Those are all.
All right. Well, thank you guys so much for coming, and don't forget to fill out the survey, those of you that are attending, so you can get your CLE credit. Thanks to everybody, and y'all have a great rest of the day.
Thanks, Judy.
Bye.